Hello, my name is Janelle and I chose to analyze these two cases. One was the British Columbia Teachers Federation versus British Columbia, and the second was Moore versus British Columbia. I chose to look at these two cases because both cases relate to British Columbia, where I would like to teach, and both cases went all the way up to the Supreme Court of Canada, where the verdict had changed. The first case was the BCTF versus British Columbia case, which was a battle concerning the class size section of the School Act. This was a 15-year battle between the BCTF and the provincial government, from which Bill 22 resulted, which stated the following. Principal no longer required to consult or obtain teacher consent or consult with school planning council regarding the organization of classes or provide a report to the superintendent on the organization of classes. Bill 22 could greatly affect teachers' ability to support all student needs and keep a safe environment for their students. Such lack of control in class sizes meant that teachers may have more students with less resources while being required to uphold all of the teachers' responsibility requirements under the School Act. The case went all the way up to the Supreme Court of Canada, where Bill 22 was deemed unconstitutional, and the threat for teachers lost to negotiate class size and composition was finally put to rest. The second case was the Moore versus British Columbia case, where the school denied a student, Jeffrey, who had dyslexia, his right to access public education because the school board claimed to not be equipped to provide the service needed for that student. Once the case went to the Supreme Court of Canada, the ruling went in favor of Jeffrey Moore because the school was still found to have funding that could have been allocated to keep the service previously provided by the school available to Jeffrey. According to the BCTF, under the Policy Statement of Inclusion, it says, every student can learn and every student is entitled to an appropriate education and full range of education services in their community. It also states that the Ministry of Education must provide appropriate funding to school districts and ensure proper supports are in place for all students with special needs and their teachers. Denying Jeffrey from being able to attend the public school because of his dyslexia went against the BC Human Rights Code Section 8, which says a person must not, without a bona fide and reasonable justification, deny to a person or class of persons any accommodation, service, or facility customarily available to the public. This, of course, ties with Section 15 of our Constitution Act. Although the withdrawal of funding occurred due to the provincial government putting a cap on special education funding, the school chose to continue to allocate funding in luxury areas instead of keeping the diagnostic center open for Jeffrey. Although these two cases are different matters, they were both important to me because it highlights that the Canadian justice system is not perfect. It shows that the one with more power do not always have the interests of those dependent on them, and that imbalance of power must be challenged from time to time. These two cases were a significant victory and were not easily won, but thankfully, the Canadian Charter of Rights and Freedoms and our democratic governance gives the people a degree of hope in demanding that the government must also include the general needs of its citizens. So why is this important to me as a teacher? Well, it is very important to support and fight against those threats against the rights of teachers, and it signifies the power in numbers through our teacher union. We continually see the decline in the status of teachers in BC, as teachers have the second lowest starting wage in the province and yet face increasing pressures to be effective teachers with limited resources and teacher shortages. I believe that being a teacher in British Columbia means that there must be some vigilance in protecting what we have in order to best prepare our students for the future and to become good citizens of Canada. This same type of vigilance is true when it comes to the rights of our students. In the Moore versus British Columbia case, the BC Supreme Court determined that Jeffrey was not being discriminated against because past cases were considered where limits to school funding was the justifiable ruling against students with learning disabilities. The Moore case, however, highlighted the danger of our legal system to overlook areas of discrimination simply because of how things were done in the past, when our education system is trying to be more inclusive than Canada's historical laws and policies have been. Canada's laws have shown a level of evolution to provide both the option to support diversity through flexibility of classroom size and composition, and also to ensure that students with learning disabilities have an equitable chance to education, but the power of our citizenship is what allows the government to continue to help change the inner workings of the system for our rights to be practiced at every level of our society. Thank you for listening.